All rise. The Court of Appeals, Division 1 is now in session.
Good morning. You may be seated. This is the time set for argument in CACV 140126, Bork versus Bork. Each side will have 20 minutes. Appellant, you'll be responsible for reserving any time that you'd like for rebuttal. We have conferenced this matter and have read the briefs. We're familiar with the issues, and we look forward to your argument. You may begin.
Judge, I'm Mark Drutz. I'm here with Jeff Gotro from Prescott, Musgrove, Drutz, Cack, and Flack. We represent the petitioner appellant, Mimi Bork. In this case, Your Honor, it's our position that the trial court abused its discretion by ignoring the evidence and the law in reaching its decision in this case. And you can see it in four areas. The first area you can see it in is our trial judge, at that time it was Judge Pro Tem Trevish, reversed the decision of Judge Ani Young that had been reached a year before regarding an award of temporary spousal maintenance that Judge Young had found that Mimi was entitled to.
Did she really reverse it? It looked like she modified.
She modified it in the sense that she reduced the amount for the first year from $2,800 a month to $2,000, and then the last 5 months she did away with it entirely. And it's our view in that regard that there was no substantial evidence in the record to reflect that. There hadn't even been a motion filed by opposing counsel asking that the temporary spousal maintenance be reversed.
Isn't there evidence, though, that the circumstances had changed?
Well, the circumstances had changed, Your Honor, in the sense that on the eve of trial in August of 2013, Mimi Bork, whose second language is English, accepted a position in Kosovo working on a U.S. military base as a linguist for $4,000 a month. It's the only position that she could find. She's from Europe. She wants to live in the United States. She has a right to be in the United States. She's a United States citizen. But she had a desperate financial situation. She knew that spousal maintenance moving into the future would be at risk. She had been looking for a position during that past year, trying to find a job as a project manager in the defense industry. That's what her master's degree is in from, I believe, NAU. And she wasn't able to find anything, obviously, in Prescott, Arizona. She wasn't able to find anything in the state of Arizona or really anywhere in the United States, and wasn't even able to find anything in Europe. Her brother, who lives in Europe and is also involved in security for the defense industry, was able to help her obtain a position on a one-year contract that could potentially be renewed for a second year, working as a linguist on a United States military base. So that's the change in circumstances, Your Honor.
Why doesn't that justify a change to the order, though? If the initial order was premised on the assumption that there was no income coming in, once income begins to come in, isn't that a basis for making a change to that initial order?
It's possible, Judge, that if we had not had a reduction in the $2,800 a month to $2,000, and there was clearly no change in circumstances that warranted that, that's a far different cry from what we see, which was the modification down from $2,800 to $2,000 for the year she was living in Prescott, and an absolute determination that she got no spousal maintenance for the 5 months that she's in Kosovo.
Isn't there a pretty clear change of circumstances that tracks that very timeline? I mean, at the commencement of the case, she was unemployed. She found a job. The job was meeting her monthly needs. And then she had a prospect of long-term employment and no longer required spousal maintenance. Aren't those exactly the circumstances that followed the orders the court entered?
You refer to it, Judge Swan, as long-term employment, and with all due respect, it's not long-term employment.
Well, no employment in life is guaranteed terribly long. I mean, unless she became a federal judge, there's not much that tells you you're going to be working 2 years from now. But the fact is, she had a very serious, credible job with the prospect of contractual renewal, and in the scheme of family court litigants, that's not a bad place to be.
Judge, that might have justified reducing or eliminating potentially the spousal maintenance for the period of time that covered the last 5 months that the spousal maintenance had been paid. That would be perhaps September of 2013 up until we got our decree in December of 2013.
You said there's no right to modify it dating back to when she obtained a job that was paying her monthly expenses.
There's no right to go retroactive before then. Where's the evidence in the record to justify a reduction for the 1 year when the spousal maintenance started? It was August of 2012. She's
Isn't
unemployed.
the justification there's zero income coming in, and once some income starts to come in, that would be a justification for reducing that amount?
I don't think that that's a justification for reducing the amount of spousal maintenance when she wasn't employed.
Isn't the suggestion in the record that the judge believed, rightly or wrongly, that some of the funds that she was receiving in temporary support she was not using for her own support, she was rather misusing for other purposes?
We have a big dispute, and that's one of the issues to talk about, is whether or not the fact that Mimi Bork used the money to repair and maintain the house that she was living in constituted waste. And in fact, the $2,800 a month that she was receiving was a minimal amount of money to pay for her expenses of living. The issue of waste pertained to the fact that Mimi took money out of community savings, as she had done before this divorce petition was filed.
Before we get into the issue of waste, though, does it even have to be waste? Those who are unable to meet their basic monthly expenses typically aren't engaging in extensive home remodel projects, whether they're wasteful or whether they would shame Frank Lloyd Wright. It doesn't really matter. The fact is, she had ample resources to devote into a highly discretionary activity, and wouldn't it be appropriate for the judge to take that into account?
The money that Mimi used to put into the house would have increased the value of the house. She wasn't spending the money on some illegal activity. She wasn't gambling it away. The fact that she was spending money to try to cure problems that the house had, in our view, doesn't constitute destruction of community property or waste.
Question. That's not my question. Let's say that she had done a fantastic job remodeling the house and increased its value. The fact is, she chose to divert money into that project because she didn't need it to buy food and gas and heat and stuff like that. She had enough, more than enough, to meet her monthly expenses, and then had enough to engage in discretionary activities, good or bad. And that seems to me relevant to the question whether the court guessed right when it said temporary maintenance.
During the first year when she wasn't working, she had $2,800 a month to live on. She didn't get any money for temporary attorney's fees. She had $2,800 a month to live on. She used that money to live on, although she had to borrow thousands of dollars from her family to supplement her expenses.
Well, where did she get the money for the remodel?
She took the money from the remodel out of the community funds.
So why did her family have to lend her money to meet her monthly expenses if there was all this money in community funds?
Well, because all the money in the community funds that she took out was probably in the neighborhood of $80,000.
That's a lot of monthly expenses.
Well, it's a lot of remodel expenses, and it's expenses for attorney's fees, and it's expenses to live on. But on top of that, we're talking about over a year period of time, she borrowed additional funds. This is undisputed from her family to meet her expenses. You know, there's two sides to every story. The other side of the coin is that the respondent in this case, John Bork, took $59,000 out of the community funds to buy himself a condo, or used it as security, froze it to pay for a condo.
But he's not asking for spousal maintenance.
No, Mimi's asking for spousal maintenance. She's asking for spousal maintenance because under 25319A, she would have qualified for consideration of spousal maintenance. Because
And that's what I question, really, because this is a community that has the good fortune to have hundreds of thousands of dollars lying around to enable remodels, purchase of supplementary real estate. These aren't people who can't meet their basic living expenses.
Well, this is a community that they had been married for 19 years. There really wasn't hundreds of thousands of dollars lying around.
More than 100.
There was more than 100. There's $141,000 in a folio account that was clearly community property that primarily had been earned from Mimi working in Iraq for 2 years in the mid-2000s. That money was all awarded to John Bork. The only thing that Mimi got in this divorce case was she got the house, which is a 1971 log cabin built out of a kit. She got that, and she got 3 old cars.
Been substantially remodeled and its value increased, I thought.
It's certainly worth more than what you might see out of a log cabin built from a kit that's 45 years old or 40-some years old.
You don't dispute the appraised value that it was worth $130,000?
No, I think that's a legitimate number. That includes, of course, the real estate upon which the house sits. So it's $130,000. That's what Mimi got. And then she got 3 old cars. That's what she got. Everything else went to John Bork. He got all of the liquid assets that were clearly community. He got everything. Mimi got all the community debt. Mimi's responsible for paying for John Bork's purchases of clothes at Brooks Brothers. Judge Trebuch ordered her to do that. Mimi spent $12,000 on a Visa card that Judge Trebuch says in her under advisement ruling was for her to live on. Because remember,
You can't just separate out the $130,000. If there were bills that had been incurred while they were married, they get paid. But if he doesn't get a comparable house worth $130,000, doesn't it make sense that she's going to be responsible for some of the debts?
well, Mr. Bork got $321,000 under the under advisement.
I do have a question about that. It
Go
seems
ahead.
to me I'm looking at the worksheet, and it lists the Georgia condominium as being worth $59,900, and then it also lists the credit union account as being worth $59,900. Did he pay cash for the condominium? Does he own the condominium free and clear, and does he also have unlimited access to the $59,000? Can you clarify that at all?
I think that's some confusion on Judge Trebuch's part. My understanding is what he did is he bought the condominium and that he froze $59,900 that was in a community account as, we'll call it, say, collateral for the condominium.
So you would agree that $59,000 should be subtracted from the $321,000 that appears on the worksheet?
It depends what the value of the condominium is. I couldn't tell you.
Assuming the value was what he paid for it of $59,000, you would agree that you should at least subtract out the amount that was encumbered?
I would agree. I would agree, Judge, that it appears to be a mathematical error that the trial court may have made, because she seems to have double charged it twice. Not the only mathematical error, if I might point one out.
Particular mathematical errors in your client's favor. It suggests that he's getting more assets, that Mr. Bork was getting more assets.
It could be construed that the judge gave him credit for the $59,000 twice. But if I might point out, if you look at the Charles Schwab account, which is on my client's side of the ledger, it's $33,000 there. The judge gives that to my client as an asset, but then below says that exact same number was wasted by my client, and therefore is double charging my client twice for that. The $12,000, similar. She says that that's a waste of community assets, even though the debt hasn't been paid, and then gives my client that debt to pay, which is a double charge to my client. So,
Do you have any calculations, if we were to not change any of the court's substantive rulings other than the allocation of assets, do you have a separate calculation for what you think the equitable or the equal distribution of assets would have been?
I think it would have been probably $40,000 to $50,000 higher than what it is right now. Certainly it would be, even with the double charge of the $59,000 on the condominium, I think it's clearly an unequal distribution because when you just do the math, even if you took out the $59,000, then it would be probably an additional $15,000 in Mr. Bork's favor, and I would contend that many of the items that Judge Trebas said my client spent were legitimate items that were spent. Not every dime she spent of the $33,100 constituted waste by my client. And there was never any parsing out by the trial court of what might be waste and what might not be.
Even if it wasn't wasteful, though, she spent it on an asset that she received. She improved her own asset, right?
She spent money on the house, and we believe the house is worth more money having bought, as an example, doors than it would be worth without doors.
Okay, that's fine. But then she got the house, and so the benefit of this money, whether it's waste or not, the benefit of this money is hers, sole and separate, now.
She spent the money and she got an asset that was worth $130,000, but she didn't spend all the money just to improve the house. She spent some of the money to live on because she didn't get any spousal maintenance for the first 8 months from January 2012 through when she finally got it in August 2012. And Mr. Bork testified that my client had a checkbook and had the right to utilize the checkbook to pay some of her expenses. There's no doubt about that. He testified to that. So consequently, it's our position that you can't say all the money that she spent went into the house and all the money that she spent was wasted. I'm running out of time. I just wanted to make one other or 2 points that I think are significant that show error on the trial court. The trial court sanctioned my client $9,000 for simply asking at trial for spousal maintenance. We think that's clearly an abuse of discretion. Judge Anna Young had ruled a year before in her minute entry that at trial we would be able to bring up retroactive spousal maintenance.
Was there any explanation for it? Was the suggestion that your client had not kept the court informed when she obtained employment? Was that the basis for the ruling?
No. The judge said that we were not being sanctioned for that. The judge felt that we were being sanctioned because she had this swell job in Kosovo on a 1 or 2 year contract that paid $4,000 a month, and she never should have asked the court to award her spousal maintenance going forward, that we never should have been able to even ask the court to reserve the right to consider spousal maintenance going forward. And because of that, my client was sanctioned $9,000 in attorney's fees, and we certainly dispute that. We also dispute the fact that the trial court determined that she is absolutely precluded, even when she comes back from Kosovo, to asking for an award of spousal maintenance, even though they'd been married for 19 years. I'm going to reserve the balance of my time. Thank you.
Good morning and thank you. My name is Victor Garnice of Nierenstein Garnice. We represent the respondent, John Bork. I'd like to briefly discuss the points raised by counsel just a few minutes ago, and of course I'm open to questions from your honors as you see fit. With regard first to the question of spousal maintenance, we think in simple terms Judge Trebish got it right. Wife was working. Wife had more than enough money to meet her reasonable needs. She no longer needed spousal maintenance. Judge Trebish went carefully through the AFIs. She considered the testimony. She considered the discrepancy between the AFIs, and she considered the testimony about the AFIs on cross-examination, by which wife indicated that a number of the charges on her trial AFI, or the most recent AFI, were simply incorrect carryovers and money that was claimed to be spent that wasn't being spent. So we think that, especially for an abuse of discretion standard, that Judge Trebish was correct in not awarding any spousal maintenance.
How about the award of attorney's fees?
With regard to the award of attorney's fees, quite frankly, I don't think it's quite as simple as appellant would have you think. There were a number of factors that we think that the trial court considered in this matter. She mentioned the claim for spousal maintenance. She thought that that was unreasonable. We think that in her under advisement ruling, the minute entry of December 31st, she also made reference to the fact that wife never disclosed that she didn't need the money for spousal maintenance that she was collecting. Made reference to the fact that she was banking it in an undisclosed bank account that wife certainly knew about and didn't disclose. She didn't have a good faith claim for the spousal maintenance.
Did the court distinguish between, was there a good faith claim at the time it was initially requested?
That's hard to tell. It could have been a good faith claim at the time that it was originally pled, because clearly she was not working. The situation of the case changed, quite frankly, after the temporary orders and after wife started working. She didn't disclose that she was working. She tried to block a subpoena to get employment information from the employer.
How long after she had started working did the court become aware, or did your client become aware that she was working?
I think less than a month before trial, which would be about a month after she actually started working. There was evidence that she had made direct deposit arrangements and so forth during the month at least prior to the disclosure. The disclosure was accidental. Wife came forward and shortly prior to trial moved last minute for a temporary orders hearing for additional attorney's fees, claiming she had no funds and needed attorney's fees. And then when the court set a hearing shortly before the trial date, a wife had to notify the court, hey, I can't be there, I need a continuance because guess what, I'm working. And so that hearing never went forward. That's the way it was disclosed. And that was, I believe, within approximately a month or 6 weeks prior to trial.
What were the attorney's fees that were incurred after she discloses that she's working? It seems like it's a relatively simple matter at that point.
Well, the attorney's fees that were awarded were a tiny fraction of the fees that Mr. Bork incurred. There are two factors at play. We know that in their brief, wife and her counsel have made reference to the disparate income between the parties, and we recognize that. We understand that under 25-324, that's a necessary factor. On the other hand, that's only one of the two legs, and I think the court had it within its discretion to determine that based upon the manner in which the case was presented and the manner in which the case was pled, that wife's claim for spousal maintenance was unreasonable as a slight offset against the disparity of income claim. Remember, if you look at the pretrial statement, wife doesn't even say in her portion of the pretrial statement going into trial, and this was filed late, a joint pretrial statement late past deadline by leave of the court.
Filed after she had obtained the employment.
Yes. And that pretrial statement didn't say anything on wife's part about employment. It didn't say anything on wife's part about entitlement to spousal maintenance. It didn't even say that she was entitled. All it said was one sentence. The court should decide whether or not wife is entitled. That's not much of a claim to make. That's a very half-hearted claim, or it puts the burden on the court to try to make a determination without a real affirmative claim. We think that Judge Trebish found that as part of the unreasonableness.
So that one sentence cost $9,000?
No, we're not claiming that the one sentence cost $9,000.
Well, what did?
We are claiming that the entire episode with regard to spousal maintenance, you mentioned it from the bench here earlier during appellant's argument about wife having discretionary income during the pendente lite period, wife's banking of spousal maintenance that she did not need to live on.
But in terms of the cost of litigating it, it seems like it's not an unreasonable claim at the outset to request spousal maintenance. It becomes unreasonable once you obtain employment that makes it so you no longer need that amount. But what's involved with attorney's fees once you find out that she's now gainfully employed?
Well, the question would go, quite frankly, to the China doll affidavits. We agree. We are not going to argue that at the outset of the case, when it's first pled as a petition for dissolution.
I'm still trying to even just figure out, though, the $9,000. It seems like a pretty easy case once once you learn that she is making more than enough to meet her monthly needs.
To be honest with you, Judge Trebish didn't indicate where she got the $9,000 figure from, and it would be presumptuous of me to guess.
I mean, typically,
I can't.
Typically, when a trial judge awards fees for unreasonableness, the fees are designed to account for the inefficiency of the process caused by the unreasonableness. Here, in one sentence, you said, "I'd like to see about spousal maintenance." The court said no. I mean, how long did that take? That just doesn't seem like a $9,000 issue.
We don't know if it was a $9,000 issue. If I stood here and said we have a China doll showing that from the time of the disclosure that wife was in fact working, it cost $9,000 in attorney's fees through the conclusion of trial and the finality of the decree.
The whole trial cost $9,000?
No. What I'm saying is we cannot quantify that. I cannot stand here and tell you that we can quantify it in that number. I do not know the source of Judge Trebish's number. And I don't know that it can be taken out of context with regard to whatever other considerations she had in balancing reasonableness.
Is that consistent with the exercise of discretion in family court, that we have opaque mystery numbers, and as long as we don't see anything wrong, we don't have to see anything right?
It would have, quite frankly, it would have been better if Judge Trebish had said, I'm awarding $9,000 in fees, and here's how I got there.
Well, and
But she didn't.
Can we uphold that without having any idea of the basis for her award?
Actually, I think that she has an obligation, if she's making an award, to give the basis of the award more than the generalities set forth in her under advisement ruling.
So you would agree then that we probably cannot uphold that ruling without some basis for?
I think if this were remanded back and require her to give the explanation of where she came up with the number, it may not be necessarily totally in my client's favor today, but it would probably be the right thing to do. With regard to the waste issue, clearly there were extraordinary expenditures, and in their brief, a wife and her team tried to simplify these expenditures in order to minimize the concept of the abuse and the extraordinary and inappropriate use of funds. So, for example, appellant argues, I needed to replace doors. It made the house better. But in fact, the testimony on page 160 of the transcript is there was one door with a non-functioning lock. She replaced the one door, which I believe Judge Trebish found to be specifically reasonable, but then indicated that replacing the other 3 doors in the house was discretionary and not needed.
Well, there's a difference between discretionary and wasteful.
Part of the problem here is that despite the large sums of money put into the house by the appellant during this period of time, the testimony of her own appraiser was that she reduced the value of the house.
Some remodels don't go well, but doesn't waste really amount to something different? Not a failed remodel project, but an actual attempt to destroy the value of the property. She didn't dig a mine in the front yard. She didn't light it on fire. She didn't rent it out to transients. She didn't do anything that would typically be calculated to destroy the community interest. She may have made poor choices, maybe not. I don't know. But maybe she made poor choices aesthetically or structurally in what she did with the residents. But why is that waste? And why is it the position of the courts to make those aesthetic judgments?
Well, because this is not necessarily an aesthetic judgment. She started off with a house. She may not have liked it. She may have had aspirations to do something with it. But once she had what was described in the case as this pre-dissolution phone call with the appellee, when she said after that call she knew the house was her to do with as she wanted, she did with it as she wanted. But what did she do? Her own remodeling plan reduced the house to functional obsolescence.
Have you ever seen these concept restaurants they build? They put in hundreds of thousands of dollars into these wide open spaces and they go out of business in 2 weeks? I mean, it may be a poor investment decision, but it doesn't necessarily mean it's waste within the definition of the law.
But it's not something that she should have been doing during the pendency of a contested dissolution of marriage action, let alone the preliminary injunction in 25-315.
She doesn't have the right to unilaterally decide on the remodel, is that?
Yes, because this is something, if she wanted to make changes, and there's a dissolution of marriage case pending, and she wants to change the house from a 3-bedroom to a 1-bedroom and to rip out the flooring and rip out the closets and the other things that were testified to, all she had to do, she already asked for a temporary orders hearing, is if she couldn't get an agreement, ask a temporary orders. Here's what I want to do with the house. Let me. She could have done that. But instead, she acted as if she owned it already. She exercised unilateral dominion and control over it. And that was the difficulty.
And I can see why the court then might say, this is your asset, you're getting it, and the amount of community funds that you spent on it should be included equitably in the division of property. I don't know if you need the doctrine of waste to get there.
I don't know that with or without the doctrine of waste, the result would have been anything different, because since the court has the authority, it has the discretion to make an equitable division, it could make that equitable division. Another example of this, for example, is the question of her purchase of antiques. She spent thousands of dollars on antiques. There were no antiques ever disclosed. There were none in any inventory of personal property. And the court, we think, did the right thing, the trial court. It said, you spent money on antiques. You spent $8,800 on antiques. We don't know where the money went. You didn't tell us anything about it. You don't have any record of antiques. You know what? You spent the money. you're chargeable with the expenditure of the money, but in exchange you get the antiques that
But
we
is
don't know
Is that
about.
waste? That doesn't seem to be waste either. That seems to simply be you spent money.
That's equitable division.
It's equitable. The point is, whether or not it's labeled as waste, the equitable division may come out the same regardless.
Could I ask about the equitable division? Just in looking at that worksheet, the court seems to be awarding the accounts that have been spent down to zero to Mrs. Bork, but then at the same time charging her with waste. So she's really not getting an asset if the asset's being listed, and then there seems to be duplication when I look at that.
Well,
worksheet.
I think what's missing from here is the fact that she was awarded whatever it is that was spent or charged or checks written for. Remember, the transcript of this thing indicated that there were a large number of checks that the appellant wrote to herself, either to cash, to her own name, or even in a couple of cases, quote unquote, to self, for which she could not account, and which on cross-examination she said she didn't know what she did with the funds. So presumably whatever it was that she purchased with those funds, which has not been disclosed, just like the antiques, is awarded to her. So she got the benefit. I'm not sure that that's quite the kind of doubling up that appellant would have the court believe.
Isn't there a different approach to funds used during divorce proceedings for living expenses and transitory purchases as opposed to assets?
I'm not.
She may not remember if she bought chicken one night with the cash she took out of the bank, but that's not really a lasting asset that she can be awarded.
Well, I don't know that we're talking about chicken or a meal or something that deals with day-to-day expenses. I believe the testimony and one of the trial court's findings was that in the first several months after the filing of the action, I think it was within 3 to 4 months, her expenditures exceeded $100,000. That's a lot of money. And if she's not going to be, that's too much money not to account for. I know that Your Honors probably were not happy about slogging through the cross-examination testimony, asking her to try to identify check by check. But the fact of the matter is this sort of encapsulated the problem. She had access to the accounts. It was that same access to the accounts could have been used to help her meet her reasonable needs and avoided the need for some or all of the temporary spousal maintenance. Instead, she applied for, obtained temporary spousal maintenance, but in the meantime was accessing the community accounts, which the appellee left available to her to be able to meet her reasonable needs, and did that, spent the money on these expendables. Let's call them options. Let's call them non-necessary expenses, and ignored her reasonable needs and asked for spousal maintenance on the side as if she didn't have these funds available. The mere fact that the funds were available didn't mean that she had to spend them or how they should be spent, and it doesn't mean that she should get a pass for having done so. Thank you.
Couple of points. Initially, my client had no employment until August 13. It makes no logical sense to go back and reduce my client's temporary spousal maintenance before that. It makes no sense to cut it from $2,800 a month to $2,000. There's nothing in the record to support that. That was a number the judge picked out of the air to reduce it from $2,800 to $2,000. Clearly ought to be reversed on that ground. Secondly, Judge Trebish's under advisement ruling is based on waste. If If, in fact, this is not an issue that my client wasted resources, and we contend it's not waste, at worst maybe some poor decisions regarding remodeling, then the case needs to be sent back in order to make an equitable division of the community property and the debt.
You agree, counsel points out that with some of the accounts, say the Schwab account, if that account was used to purchase antiques, it doesn't show up on the balance sheet that she now owns $8,000 in antiques. And that should be, so that's not necessarily a double counting when we go down to the expenses out of the account. Does that make any sense?
Well, no, it does, but it does, Judge. It shows my client under her share, her list, $8,733 of antiques. That's what my client was awarded as part of her $246,000. Then where did that money come from? That money came from either the Charles Schwab account or the IBM account. She got that too. She's being charged it twice. She takes the money out.
So your position is there are no assets that she has separate and apart from those that are listed here that were purchased with the credit union account or the Schwab account.
Right. The money that was used from the Schwab account, the credit union account, was for her living expenses that covered the period of time January 2012 to August 2012, in which she got no spousal maintenance, in which opposing counsel indicated that my client had the right to withdraw money. It included payment of some attorney's fees, and it included purchases that they contend is waste, but we're being double charged them. We get the money out of the Schwab account. That's part of the $33,000. We use it to buy antiques. That's $8,000, and that shows up on the same side of the ledger sheet. We're paying it twice. Then we're penalized for it by saying you never should have done it on top of it, and it all constitutes waste. Everything my client did, this judge found was waste. The $9,000 was a sanction because my client had gotten a job in August of 2012 and went to trial and asked for spousal maintenance. Many cases in which somebody goes to trial and asks for spousal maintenance where they're employed. Thank you, Your Honors.
Thank you. Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course.